Welcome to Tompkins Talks. It's time for another summary of a recent case in a short, snappy way that's easy to digest, whether you're at home, in the office, or on the move. The people have spoken via a LinkedIn poll and asked me to talk about a case about break notices and implied terms. So today I'm going to talk about the case of Wigan Borough Council and Scullingdale Global Limited. I've got my coffee, I'm in the sunshine in the garden, so let's get started with the backstory. The council owned a stately home called Hay Hall, which was let to Scullingdale for a term of 199 years for a premium of £400,000. Scullingdale was to convert the property into a hotel and wedding venue. The lease stated that Scullingdale was to commence the redevelopment works within 6 months of the date of the lease and complete the development by the 23rd of May 2018. If it failed to meet either of these milestones, the council could terminate the lease by serving a break notice, giving not less than 2 months' notice. If such a notice was served, compensation would be payable by the council to Scullingdale at the lower of either the open market value of the property or £400,000, i.e. the premium paid, plus the value of the improvements. You can probably see what's coming, but Scullingdale failed to complete the development by the 23rd of May 2018, so the council served a break notice on the 16th of September 2019 to end the lease a couple of months later. Scullingdale refused to vacate, so the council brought a claim for possession and damages for trespass, which are known as mean profits. Scullingdale defended the claim on the basis they said the break notice had not been served in a reasonable time and was not valid. So what was the outcome? Even though the council could, in theory, have served the notice at any time during the 197 remaining years on the lease following the breach, the court found there was no term implied into the lease that the break notice had to be served within a reasonable time of the right to serving accruing. If Scullingdale had wanted to make time of the essence, it could have given notice of that to the council, following which the council would have had to serve within a reasonable period. However, as Scullingdale didn't do that, the council did not have to serve the notice within a reasonable time of the breach. What the court did find was that a term should be implied, that the break notice could only be served by the council if Scullingdale was in breach on the date of service, and on the facts, Scullingdale was in breach when the notice was served. Now, it wasn't all bad news for Scullingdale. They did succeed in their defence against the claim for damages for trespass on the basis that the council had suffered no loss. And one other interesting point from the case is just a comment, really, on the effect the pandemic has had on the value on the hospitality sector, because it was found that the market value of these premises had decreased by some £1 million between the date the notice ended the lease in November 2019 and the date the matter got to trial. In sporting terms, the judge said the matter was an equivalent of a 20-6 points win for Wigan Warriors or a 4-1 win for Wigan Athletic, with the council, of course, being the Wigan teams in each case. So what does this mean? Well, the case, of course, turned on its own individual facts, but it's a good reminder of when courts might imply terms into a lease. Scullingdale was scuppered here by the fact that the wording of the break clause didn't limit when the council could serve a notice. So it's a great reminder to take care when drafting provisions such as this to ensure that all circumstances are taken account of. If you found this useful, please comment, like or share the video. I'll see you again soon for another Tompkins Talks, and I hope you and yours stay safe and well.